Purcell is here for Anesthesia Medical Group. I would like to reserve 5 minutes for rebuttal, and Mr. Miles will handle the rebuttal, if that's okay.
Okay, 5 minutes.
All right. This case arises from the defendant's motion to dismiss based on plaintiff's failure to state a claim upon which relief can be granted, because the lawsuit was filed after the statute of limitations expired. The plaintiff, Ms. Burma Anderson, as administrator ad litem for the estate of Ms. Page, did not serve pre-suit notice at all prior to expiration of the statute of limitations.
Is that all really fair there? I mean, she did make an initial contact of St. Thomas, and St. Thomas said, you're not the right party, we're not going to move forward with you. And that all seems an impressive statement.
Well, I put she did not serve pre-suit notice as administrator ad litem at all. She served pre-suit notice as mother and informant when she did not own the cause of action.
What should she have done here? What should Ms. Anderson have done?
Ms. Anderson is charged with knowing that the cause of action passed to Gerald Page.
And Gerald Page did provide notice, right?
He did, yes.
And it was timely.
It was before expiration of the statute of limitations, yes.
Which to me means timely.
It's timely, well, I'll put it this way. It operates to extend the statute of limitations by 120 days if it is one timely and substantially complies with the requirements of the pre-suit notice statute.
Right. Was there any deficiency with regard to the notice at that time when it was provided? Is there anything errant about, if there had never been a change, if Ms. Anderson hadn't taken over, the case had continued with Mr. Page, is there anything wrong with the pre-suit notice?
If Mr. Page had been the one to file the lawsuit, there would have been nothing wrong.
So it was a perfectly appropriate notice for him as the party proceeding?
For him, yes. That is something I will hope to address a little bit further.
So what in law prohibits the administrator ad litem here from taking advantage of a properly filed pre-suit notice by another appropriate party? I mean, what prohibits that?
The plain language of the statute and the case law that's interpreted the statute since then. So
is that IGU? What is that?
It's part IGU, part this Denson case that we've cited, which I can go through briefly. The facts there was grandmother served pre-suit notice, did not identify the children of the decedent, her grandchildren, as claimants in the case. When she filed the lawsuit, she identified herself individually and on behalf of the minor children beneficiaries. And the Denson court held that did not substantially comply with the pre-suit notice requirements because it did not identify who the plaintiff was. This case is even worse because it's not like Mr. Page filed the lawsuit and said on behalf of additional claimants. Mr. Page is not the plaintiff. Ms. Anderson is now the plaintiff. And the problem comes, as they went through in Denson, is that different plaintiffs in a wrongful death case change the value of the case.
Is there anything, Ms. Anderson, under your interpretation of this statute, is there anything Ms. Anderson could have done for this suit to be timely filed?
As soon as she knew that her daughter had died and that her daughter's husband had abandoned him, she had 12 months within which to accomplish being appointed as administrator ad litem. Ms. Page, the decedent in this case, died in June of 2022. The petition to be appointed administrator was not filed until March of 2023. 9 months later is when she first took action. And it did not take long for her to be appointed. It was within 4 months, but because of the delay in seeking the petition, she was not actually appointed until after the statute of limitations had expired. She also could have just filed a lawsuit within the statute of limitations. It would have been dismissed.
Could she? I mean, she wasn't the proper party to file until Mr. Page is replaced in the case. And
it would have been, well.
How is that different than her starting the process of pre-suit notice? I mean, you're You're saying she could have filed an invalid lawsuit that she couldn't file because she wasn't the appropriate party yet. How is that different in terms of starting the process than her contacting St. Thomas and saying, I think you guys were negligent. I want to move forward with this, and then St. Thomas responding, we don't think you're the proper party?
Because it would have commenced an action. Once you commence an action, unless it's dismissed with prejudice, it can be filed again a year later. She could have had another opportunity and would have been appointed administrator ad litem, refiled, or given proper notice after the dismissal without prejudice, given proper notice and refiled and have complied with everything that needed to be complied with in that second suit. Or she could have let Gerald Page file a lawsuit and then sought substitution once the action had been commenced. But here we did not have any action commenced within the original statute of limitations. The only person who could have, who the plaintiff was, who Stevens says, this is Supreme Court Stevens case versus Hickman County, one of the most important parts of pre-suit notice is identifying who the plaintiff is. And this didn't happen here. And when Mr. Page served pre-suit notice, the plaintiff was a husband who had abandoned his wife. This is in the record, within the pleadings now. A husband who had abandoned his wife. What is the value of that consortium claim for the husband? Then when suit gets filed, it's not Mr. Page. It's Mrs. Page, the loving mother, which greatly increases the value of the wrongful death action, which falls right in line with the reasoning of Denson, which is why that case was dismissed, because adding the children as claimants increased the value of that case and was prejudicial to the defendants. So hopefully I've addressed that argument as best I can. Let me see. There's something I might be missing here. Go ahead.
In Denson, though, the wrong party is giving pre-suit notice, and you don't dispute that Mr. Page was the right party when he provided pre-suit notice.
The wrong party was not giving pre-suit notice. Did give pre-suit notice in Denson. The grandmother there was nothing wrong with her as the correct plaintiff. She gave pre-suit notice and she filed the lawsuit. She just added that she was filing on behalf of children as well when she had not identified the claimants as children in the notice. And the court found that was sufficient to provide prejudice. Here, the person who served pre-suit notice did not even file the case, unlike in Denson. Here, the person who served pre-suit notice didn't file the case. It was the first time Ms. Anderson served pre-suit notice with authority to do so was after the statute of limitations. So, the statute says, any person or that person's authorized agent asserting a potential claim for health care liability shall give written notice of the potential claim. It didn't happen here. That's the statutory language. The plaintiff in the case has to serve pre-suit notice. The plaintiff in this case is Burma Anderson as administrator ad litem for the estate. I'll note also regarding the August 22 pre-suit notice that she filed as, quote, mother and informant, that the argument that that is somehow satisfactory or relevant was not raised by the plaintiff in the trial court. It was not briefed by the parties in the trial court. It was not considered by the trial judge in the trial court. It was also not raised by the appellees in this court. It was not argued by the appellees in this court. And in fact, the appellee's statement of the issues is whether the trial court correctly denied the motion to dismiss when it held that the statute operates to extend the statute of limitations applicable to appellee's health care liability action for wrongful death based on pre-suit notice served by her preceding next of kin. The issue to the appellee in this case, as it has always been, is whether Gerald Page's pre-suit notice is sufficient, not whether her invalid pre-suit notice earlier is sufficient. I think it's fairly well been conceded that it's not, because it is a nullity. She didn't have any right to do it. It's not pre-suit notice when she didn't own the cause of action. Does the statute mean anyone can jump in and serve pre-suit notice, and that is meaningful when they don't have the cause of action? That's my time, Your Honors. Unless there's further questions, I will step aside.
No further questions.
Good afternoon. May it please the court, my name is Damon Duggar. I'm with the Office of Lavelle L. Glanton on behalf of Burma Anderson individually and as next of kin of Latasha Lissay Page. We would submit that the pre-suit notice supplied by Mr. Page is sufficient, and it can be relied on under the wrongful death statutes in this state. Excuse me for a moment. The appellants, in their brief, state at page 8, the purpose of Tennessee's wrongful death statutes is to provide for the continued existence and passing of the right of action, not for a new cause of action in survivors. And we would submit that the next of kin is the proper plaintiff in this case. The next of kin at the time that pre-suit notice was filed was Gerald Page. Mr. Page was disqualified as having abandoned Ms. Page under 364101A13. The trial court did not, as you know in the record, the trial court did not cite specific cases or statutes in its ultimate decision that 2926.121C functions to extend the statute of limitations in a wrongful death action, but its reasoning does comport with the wrongful death statutes in the state. Specifically, Tennessee Code annotated 25107E4 reads, in no event shall any cause or any action for wrongful death abate or the statute of limitations bar an action solely as a result of a finding the surviving spouse's rights are waived. Instead, the court shall substitute the proper party. Moreover, Judge Binkley drew a distinction, the trial court drew a distinction between those cases where we have a loss of consortium deriving from an injury in a medical malpractice claim, whereas we have a loss of consortium claim arising from a wrongful death claim here. I would ask you what would happen if, say, Mr. Page had died on the 13th month. I guess the cause of action would have evaporated completely. What if he'd had kids? Are they out of luck? They can't file pre-suit notice now because the statute of limitations passed, because they are a brand new plaintiff. The wrongful death statutes, taken together, set forth the priorities among persons entitled by Tennessee Code annotated 25107 to bring a wrongful death action. Superior right lies with the surviving spouse. If there are no surviving spouse, the children of the deceased have priority to bring the action as next of kin. If no children of the deceased are surviving, then the priority passes to the next of kin. The appellants in this matter, in both their brief and their reply, repeatedly refer to Mrs. Anderson as a competing claimant or a third-party claimant. We take issue with that. She was the next of kin, and the rightful next of kin under the law of the state as found by the probate court in Davidson County.
Counsel, your statutory interpretation argument in connection with the wrongful death statute, opposing counsel suggests that it's been waived. You presumably don't agree with that. Why hasn't this been waived here in your view?
Why has this not been waived? I would say because it's black letter law. I don't think we're making an argument so much as this is how the law functions. This is not an interpretation of a case. This is not our interpretation of, I would say that this is us quoting the law as it pertains to wrongful death suits. And this is the supports the conclusion that Judge Binkley came to in his findings at hearing. Let's see here. We also argue that, obviously read in pari materia with the other wrongful death statutes as prescribed by this court in Foster v. Jeffers, specifically that all the wrongful death statutes must be construed with reference to one another. A proper party shall be substituted where the right to institute and collect proceeds from a wrongful death action is waived, and the next of kin has established that the surviving spouse has abandoned the deceased per Tennessee Code annotated 36-4101A13. Excuse me. Now on to the pre-suit notice. Of course, we submit that the appellees substantially complied with the directory requirements of Tennessee Code annotated 2926-121. We take no issue with the appellant's assertion that pre-suit notice is strictly construed and must be given. However, Tennessee Code annotated 2926-121A2, such notice shall include the name and birthday of the patient at issue, the name and address of the claimant and their relationship to the patient, the name and address of the attorney sending notice, a list of names and addresses of all providers to whom notice is being sent, and a HIPAA-compliant medical authorization permitting the provider receiving the notice to obtain complete medical records. These may be satisfied by substantial compliance per this court in Moxley v. Amasub. That's number W2023-002200. Would you like me to give you the entire citation? Or? Okay. COA R3CV, and that's 2024 Westlaw 176-5046 at star 5. That was February 24th of 2024. Strict compliance with Section 129 is not required for substantial compliance, as the ultimate purpose of the pre-suit notice requirement is to allow potential defendants to investigate the merits of the claims against them and to pursue settlement negotiations prior to lawsuit being filed. That's Moxley at star 5. If non-compliance neither frustrates nor interferes with the purpose of Section 121, nor prevents a defendant from receiving the benefit that the statute confers, then a determination that the plaintiff has substantially complied is more likely. We would submit that Mr. Page's pre-suit notice put the appellants on notice that a wrongful death suit was being filed by the next of kin, by the lawful next of kin at that time.
Opposing counsel makes the argument that draws a distinction between the notice and filing suit in terms of succession. Why is that argument not availing in your view? And isn't there a division to be drawn between her succeeding to the suit versus her succeeding to the notice here in this case? I mean, the notice that's provided is as to the estranged husband bringing suit. Why isn't that a sufficient difference to essentially render this a nullity?
I would say that it doesn't have so much to do with the case being filed as the next of kin, the lawful next of kin filing notice. If this answers your question, the lawful next of kin provided the notice. He was disqualified. So the next of kin, the lawful next of kin, can operate. The claim brought pursuant to the death of Latasha Lissay Page can still be asserted because they have the appellants have received notice that a wrongful death suit is being sought, and they had an opportunity, they had ample opportunity, as they pointed out, to seek settlement with Mr. Page. They did not seek that. That is, I believe, in the record. Finally, the trial court's findings are consistent with statutory and case law regarding wrongful death actions. As I said earlier, Judge Binkley made a distinction between those cases where a loss of consortium claim is derivative of another's medical malpractice claim, of a living plaintiff's malpractice claim, versus that where a loss of consortium claim arises from a wrongful death claim. And we would submit because the loss of consortium claim being asserted by Mrs. Burma Anderson arises from the wrongful death claim, it passes per the statute since Mr. Page was disqualified. I'm not sure that filing sooner was really an option, and she did make every effort she could to provide notice. She provided notice initially, was informed that she was not qualified to do so. Soon after Mr. Page filed suit, she challenged him in the probate court for a variety of reasons. As is cited in the briefing, that was delayed until the expiration of the original statute of limitations, the 1-year statute of limitations. But we would submit that Mr. Page, having filed pre-suit notice, extended that to 120, or extended it by 120 days, which would put it somewhere in mid-October. She finally filed suit in late September. I believe that is all. Thank you, Your Honors.
Okay.
Good afternoon. Eric Miles of the Nashville Bar. I represent Anesthesia Medical Group. I'm going to try to respond to some of the arguments and questions. The question of whether it's strict compliance or substantial compliance here is answered by the fact that it is mandatory that the actual plaintiff give pre-suit notice before filing suit. That did not occur here. The question as to whether or not substitution can occur pre-suit, although we do submit that that argument was waived by the appellee, is still resolved by the fact that there is no substitution available in the pre-suit phase. Substitution becomes available when an action is commenced. An action is not commenced until a lawsuit is filed. The rules of civil procedure do not apply in the pre-suit notice phase. A pre-suit notice is simply information to a potential defendant that a lawsuit may be commenced. So there was no substitution argument to be made because no substitution could occur in the pre-suit phase. The questions that Judge Usman, you have raised, for example, about what could have been done, I think are questions that are reasonable and need to be asked in this case. One of the things that I think jumps out is the timing of all of these letters. I would point out that Mr. Gerald Page's last pre-suit notice letter, which was the first time my client was notified of a potential lawsuit, was January 1, 2023. Under 2926.121, a plaintiff must wait 60 days to file suit after giving notice. Gerald Page could have filed a lawsuit on March 1, 2023, and that suit would have been within the 1-year statute of limitations. And at that point, the argument in probate could have occurred and a substitution could have happened. But there was no lawsuit filed by Gerald Page. If we turn the clock back to the question about what was Miss Anderson supposed to do given this issue, we know that her letter for which she had no authority to send to St. Thomas was sent in August of 2022, less than 6 weeks after Ms. Page's death. Counsel for St. Thomas, Mr. Holmes, sent a letter advising that you do not have authority under HIPAA from what we can tell, and we can therefore not comply with 121A5 because of HIPAA.
Does that put your client in a different situation than St. Thomas in terms of the questions that are before us in this case? And St. Thomas is contacted by Ms. Anderson. Your client is not, and she's not the appropriate party to contact. Is your client differently situated than St. Thomas in this case?
I think yes and no. I think yes, clearly, because we never received notice from Ms. Anderson. So there is no gray area question about was this August 2022 letter pre-suit notice. We never got any pre-suit notice from her. So in that sense, it is black and white in the way that the IGU case was decided. You must have pre-suit notice from the plaintiff. The only reason I say no is because the letter that was delivered to St. Thomas was clearly not proper pre-suit notice. And it's important to note that
Not proper because she wasn't the right party or some other defect? And-
That and the defect is, my client was not included on that notice letter, and my client was ultimately sued. The
Is that a result of some deficiency by Ms. Anderson, though, or the lack of information that she was given in response?
Well, I would submit it's a deficiency because she wasn't the proper plaintiff, the proper potential plaintiff, because she was informed very early on that St. Thomas could not release that information. What followed, of course, was a letter from Mr. Page. But the bottom line is that when they gave that pre-suit notice and they exclude a potential defendant, at no point in time did Burma Anderson ever give notice to St. Thomas that allowed St. Thomas to use her authorization to obtain records from the other potential defendant, which in reality was actually named in the future lawsuit by Ms. Anderson. So that's a lack of compliance. Now, we've argued about that, even though that argument we also submitted is not raised or relied upon by the plaintiff, but I did just briefly want to address the question you asked about what could she have done. And I know I'm very short on time, if you'll indulge me. She could have filed suit. There's no question about that. We've already addressed that Gerald Page could have filed suit, but I think in this case, it's very important to look at the dates. Look at the amount of time that passed. September 22, letter from Mr. Holmes to Mr. Glanton, her lawyer in this case. That's when that letter was sent. It was 6 months before action was taken in probate court. The statute of limitations is the statute of limitations. It expired on her claim. Thank you.
Thanks to everyone. That concludes the docket for today.